there on some of the pleadings or something.
I don't remember, I don't recall that in her name, but yeah, that's good.
That was pleasant.
And one of our partners was at before she came here.
Her name was Jim as well. Probably took her spot. Had to change the last name.
Oh, okay.
I don't know.
Yeah.
Sorry. You took a roll before you got out here. It's a great question, sorry, I didn't think about that.
I was trying to shape the
You get caught up. Yeah, that's right.
All rise. Hear ye, hear ye, hear ye. The Court of Appeals of the State of Kansas is now in session. The Honorable Sarah E. Warner presiding.
Thank you very much. Good to see everyone. Please be seated. Good morning. And welcome to the July oral arguments before the Kansas Court of Appeals. My name is Sarah Warner. I am joined today by two of the distinguished members of our court. So I'll start by introducing to my right, your left, Judge David Bruns. Judge Bruns has served on our court since 2011. And before joining the Court of Appeals, he spent a decade on the district court bench in Shawnee County. And before that, was in private practice in Topeka.
I didn't know I was that old.
And then to my left, your right, is Judge Lori Bolton Fleming. Judge Bolton Fleming is the newest member of our court, having joined the Court of Appeals in April of this year. She comes to us after serving as Chief Judge of the 11th Judicial District, which is in Southeast Kansas. We should all know that, but just in case. And before joining the district court bench in 2012, Judge Bolton Fleming was in private practice in Southeast Kansas. I'll be presiding over today's docket, which really means that I'll be operating this. It's a very old timer. I think it may be the first digital timer that was ever created. And so to the extent there is any operator error, please just work with me and we'll go with that. We will be hearing 3 cases on this morning's docket. The first case is scheduled for 20 minutes of argument for the appellants and 20 minutes of argument for the appellees. But we'll deal with that in just a minute. And the other 2 cases have 15 minutes of argument on each side. In preparation for today's arguments, we have thoroughly reviewed the parties' briefs and the court record, along with a legal memorandum that's been completed by a research attorney working for the court. So we are very familiar with the facts and the arguments that are presented in each of these cases. But because these arguments are being live streamed on the Court of Appeals YouTube page and being recorded, I'm going to ask the appellant in each case to take a minute or two to just describe basically what the case is about and why we're here. And that minute or two will not be counted against your time. Just that allows, the masses who want to watch these arguments later on to have some context. With that, I will call the first case on this morning's docket. It looks like everyone is already set, but this is from Shawnee County. Case number 127514, NCR Corporation Appellee versus Raytheon Company Appellant versus the Kansas Department of Health and Environment Appellee. Would the parties please state their appearances?
Thank you, Chief Judge. For the appellant, Zach Chaffin McClure, I'm joined by Jamie Thompson and Dalton Mott.
Thank you very much. And Mr. Chaffin McClure, will you be arguing?
I will, yes.
All right, thank you.
Good morning, Your Honor. For NCR Corporation, David Romine, will be arguing with me, Larry Silver and David Traster.
Thank you very much.
For Appalachian Kansas Department of Health and Environment, John Trong, I'll be providing arguments here, and I'm joined by Daniel Wallen.
All right, thank you, thank you. This case, you all may be seated, and we'll have a little bit of a conversation here. If you don't feel like you need to stand up during that conversation, but this case is scheduled for 20 minutes of argument for the appellants and 20 minutes for the appellees. Have the appellees decided how they would like to divide up that argument?
Yes, Your Honor. So during the appellee's argument, NCR Corporation will go first. And at approximately the 8-minute mark, without trying to overstep the court's questions or fill a sentence, approximately the 8-minute mark, I'll stop my argument and KDHE argument.
And just so I am clear as the glorified timekeeper here, for the 8-minute mark, do you mean 12 minutes into your argument or 8 minutes into your argument?
8 minutes into NCR's argument.
Okay,
The
all right.
reason being that KDHE has an issue additional to the issues that NCR will be arguing. It's a due process constitutional argument that I'm sure the court's familiar with.
Okay, thank you very much. I appreciate that. And Mr. Chaffin McClure, would you like to reserve any time for rebuttal?
Yes, I'd like to reserve 5 minutes.
5 minutes. Well, give me just a second as I figure this out, and then we will go from there. All right. Looks good. Counsel, you may begin.
May it please the court, Zach Chaffin McClure for the appellant. Should I begin with a quick synopsis for the masses?
Yes, and then like I said, about a minute or two, and I'll go on ahead and start this timer.
Sure. Okay. Well, this appeal comes from the district court. It started as an administrative action, and it started with a unilateral order issued by the KDHE related to a facility in Wichita, where the KDHE found that two parties were potentially responsible for environmental contamination at that site. The case was heard by an administrative law judge, and findings were made that Raytheon was responsible and that the other defendant, NCR, was not responsible. That matter was appealed to a district court judge in Topeka, well, first it was appealed to the head of the KDHE, then it was appealed to the district court in Topeka. Both times the decision was affirmed. So now we're here on appeal again to argue our points before this court.
All right, thank you very much.
So with my time today, what I would like to address is I want to start by explaining how we see the various successor liability rules announced by Kansas decisions interacting. Second, I'd like to speak quickly to the key facts in the record that we think demonstrate that summary judgment should not have been granted against us on the issue of NCR's direct contamination through its operations at the site. And then I'd like to quickly address the due process defense and how that relates to the summary judgment standard. But the first issue is really the meat of this appeal, right? It's the question of what does Kansas successor liability law say about a fact situation like we have here?
Before we get there, can we do a preliminary issue, which is, I notice you and NCR agree on the standard of review, but I don't think the state does. What is our standard of review in this case?
It's de novo. We think that's true based not only on the statutory factors we're basing our appeal on, but simply also because even if we didn't have those statutory factors under the Administrative Law Act, it's review of a summary judgment motion. We lost at the summary judgment level, so it's de novo review. And that's what the Wells Fargo case says is true as well. So that's how we see it.
Are there any different procedural mechanisms that occur at the agency level that in a summary judgment proceeding that we need to be aware of?
We think it's treated just like summary judgment in the district court. In other words, the case law in the state says that it's still the same standard you find under 60-256. And there are some pretty important uncontroverted facts that I'll get to here, but it's just a straight up review of summary judgment.
And along those same lines, so you briefly raised choice of law,
Sure.
comparing New Jersey and Kansas. I don't think you raised that at the district court level, and it's kind of a moot issue because it's the same law.
We argue it's moot, but there's actually a mistake in our brief. We cited volume 7, page 42 by mistake. It was page 8 of the wrong reply brief. It was cited in the district court. It's in the record at volume 14, page 35. But that's my error in the brief. But our position is that New Jersey law is really no different from Kansas law. So it's not a true conflicts of law issue. And
Unfortunately.
we'd all love to have one, but here we are. So for us in Kansas, there's really two top level rules. There's the rule announced or summarized in Comstock, which simply says, as a general matter, if you absorb a corporation, if you consolidate with a corporation, if you take on its operations through other means, you take the liabilities with that corporation. They don't get separated. That's a general rule. And so it's not an exception to the general rule, but a different general rule that was stated in Wells Fargo, which talks about the asset purchaser. And the thing we really like about Wells Fargo is that it is crystal clear that the asset purchaser rule requires more than just, well, I've purchased the assets. It has to be between contracting corporations dealing at arm's length. It has to be for fair value. And as the court said in Wells Fargo, this rule cannot be applied where the negotiators for both corporations are the same or virtually the same, et cetera. There are all these caveats to it. So it's a multifactored rule that NCR must avail itself of. And since that's the rule that the ALJ decided the case upon, that's really where we say the heart of the error is. Now, below those two rules, however, there are even exceptions to the asset purchaser rule. And those have been briefed before, but they've not really been analyzed in the rulings that lead to this appeal. So neither at the administrative level or the district court level do we see much analysis. And our point here is that that is error because the court had to, or those decision makers had to address the exceptions to the Wells Fargo rule, the mere continuation doctrine, the de facto doctrine, the implied assumption doctrine. And
It appears that both the ALJ and the district court decided that because we don't have any Kansas decisions that specifically say that a division rather than a full absorption would trigger those exceptions, then those exceptions do not apply. Could you respond to that?
That's exactly how we read it. And we think that's very problematic. That's a hard position to defend. I mean, even the 10th Circuit decision, Moore, which summarizes Kansas law on successor liability, says Kansas is even more technicality averse, for lack of a better phrase, than a lot of other states. In other words, Kansas would be one of the states least likely to have an issue of successor liability be decided on such a technicality. The theme running through Kansas successor liability cases is substance over form and trying to avoid loopholes or gotchas that let corporations do some sort of maneuver to say, I get to keep the assets, I get to keep running the business, and now I don't have any liability. In this case, when we look at the transaction that led to moving SPD from new ECI into NCR, if you think about if that's all it took in order to just separate a company's historic liabilities from all of its revenues and its operations, et cetera, this would be a huge loophole for companies to do. And it just demonstrates that this wasn't an arm's length transaction. There are really three key points that I think make that crystal clear. The first is look at the Venn diagram. At the point in time, the magic trick that NCR says it pulled here, where it got to take all the operations of SPD and all of its contracts and all of its customers, but none of its liabilities, was when it took SPD out of ECI and moved it over to be a direct asset of NCR. But at the time of that transaction, what they framed as a dividend in kind, the Venn diagram here was NCR is the big square, and inside NCR is a little circle called ECI. And SPD is part of ECI. They just moved it over from their wholly owned subsidiary to the parent company. Now, if companies could do that, if they could just shift assets from one subsidiary to another or from a subsidiary to a parent and suddenly not be liable for the history of the company. That would be a huge loophole. We think Wells Fargo says you can't do that because it's not arm's length. And we've cited other authorities to that effect as well. But that's exactly what we see the hang up was at the levels of review below. They said SPD is technically not a formal company. It's a division. It's a line of business. How do we deal with that? We think Kansas law says you look at it exactly the same.
Would that analysis change if at the time ECI was not a wholly owned subsidiary of NCR?
Sure, that would make a difference. I don't know that that would be a dispositive difference. I mean, another key theme from the Kansas cases is these are fact intensive and you have to weigh all of the factors. And so even if there were a different setup that allowed them to get past the general Wells Fargo rule, we'd still be entitled to argue mere continuation, implied assumption, et cetera. So it would depend. But for us, it's important that statement of fact number 47 from our summary judgment motion went uncontroverted. And so we discussed this in our reply, volume 12, page 51 in the record. What that 47 said was NCR absorbed substantially all of the SPD assets. So we've checked that box, uncontroverted. Next, the fact that NCR relies on a dividend in kind, you go to look at that document, you look at the battle plan, and the dividend in kind was not just the assets, but, quote, and the business conducted by such division. It wasn't just an asset purchase, as they've tried to frame it. And they would need to frame it as that in order to avail themselves of the Wells Fargo rule. But they also took the business. What does that mean? That means the operations. And under the Wells Fargo rule, that means it's not a magic trick. You don't get to split the liabilities. And then finally, although this really doesn't jump out of the appeal briefs, it's very important that this was conducted as a tax-free dividend in kind. So the battle plan that was orchestrated made this a tax-free transaction. And that's actually legally important. And so the cases we cited, volume 12, page 40 in the record, show why a tax-free transaction like this is necessarily incompatible with an asset sale. It can't be both. They already availed themselves of the advantage of doing it as a tax-free corporate restructuring because that's what it was. And so to say now it was something else, we think is a very uphill battle for them. It's just shuffling an operation from a subsidiary to a parent.
What's your position as to what I think you referred to and the briefs referred to as the new ECI?
Sure.
Was it simply a merger or transfer vehicle in order to transfer stock from SPD or whatever it was at that time? It may have been Standard Precision Inc. at that time, but regardless, to transfer stock to NCR, or did it actually independently do business?
No, it was new ECI was a shell company formed for the explicit purpose of squeezing out the minority
So
shareholders.
basically, it was a merger vehicle or a transfer vehicle.
It was, and that's not a dirty word. Companies are
No, it's
allowed
done
to
all
do
the
that.
time.
Right? Yeah, you're allowed to squeeze out minority shareholders. An important thing for this appeal, however, is that's not the magic trick. That's not the thing that NCR says gets them off scot-free.
No, but it is kind of the missing link in all this. What is that step? And they may have a different position than you do. I recognize that.
Sure. But as we understand it, that move, taking the assets from old ECI to new ECI, they're not saying now new ECI had no liability. Everything was still there. Everything that was in old ECI was in new ECI from their perspective and ours. For us, the question then becomes, what was left in ECI when E-Systems bought it years down the road? And our whole point is, in order for NCR to say we took the assets and not the liabilities, that magic trick has to be in that step, in the dividend in kind. And we just think, given the fact that they structured as tax-free, given what was uncontroverted in the record, there was no basis for granting them summary judgment on that issue. Clearly, there were facts from which a fact finder could have said, no, the liability went with the company. And that was the result in Ledbetter. That was the result in Avery. It should have been the result here.
Counsel, I know you have other points that you'd like to discuss, but before we go there, I was wondering if you could talk a little bit about this determination, weighing all the factors, looking at the potential exceptions and ultimately deciding where liability goes. What is that determination? Is it an equitable finding? Is it a legal finding? Is it a factual finding?
We view it as a legal finding or a legal conclusion. It's true that the successor liability cases in Kansas talk about successor liability as being fundamentally an issue rooted in equity because we are concerned about fairness. Can companies do a magic trick that says now I can continue doing business and I don't have to worry about my past liabilities? That's a fairness consideration. But the way the case law is developed, it's clearly a legal conclusion at the level below.
Thank you.
Okay. So based on that, based on the summary judgment record we had here, we think it was error to grant summary judgment to NCR on this issue. We think we were entitled to summary judgment because the key facts were uncontroverted as to how these transactions were done. The question that just hasn't been answered below was, what do we make of the fact that SPD was a line of business? And of course, we cite cases outside Kansas that explain that really doesn't make a difference. And they talk about the same themes of equity and so on. You know, the Koch case from New Jersey is key. The National Credit Union Administration versus Wells Fargo out of Connecticut is very helpful. And the Pool case out of California, although decided in a removal context, is still also very helpful. The Connecticut one and the California one both explicitly reject the argument that a transferor corporation's continued existence makes successor liability impossible. They say, oh, well, of course you can impose successor liability upon the transfer of a line of business. It doesn't have to be a formal legal entity. So quickly here, before my 15 is up, I want to turn to some fact evidence in support of NCR's direct liability. Did NCR directly contribute to environmental contamination? And we say we should not have had summary judgment granted against us on this issue either. The two key documents that put into the record facts of their contamination are the Walsh affidavit and the Connor report. So the Walsh affidavit is something that NCR prepared. It's at volume 8, page 98 of the record. And they talk about using chlorethane new at the site. That is TCA. And so when our expert, Mr. Connor, whose report appears at volume 10, page 32, is talking about TCA, they're talking about the same thing. But Ms. Walsh also talks about how NCR continued to manufacture the ball printer mechanism after what she calls the acquisition of the SPD. Okay. And so when we know that they were continuing to do some of the same work using the same product, at least one product, and they were using this chemical TCA, Mr. Connor was able to take that information and draw conclusions that, number one, since TCA and TCE are typically not used for radium stripping, but for other manufacturing processes, that's strong evidence that the TCA contamination identified by the KDHE is attributable to NCR directly. And number two, he concludes that the sump continued to be a source of contamination after the acquisition and continued to be used by NCR. And that's true, notwithstanding their evidence that one floor drain was sealed. Those aren't two necessarily incompatible things. So because there were facts in the record that a fact finder could have found NCR directly contaminated based on those facts, they shouldn't have had summary judgment on that issue as well. But that is the end of my 15. So,
all right.
definitely.
Are there any other questions from the panel?
Not at this time.
No? Okay. Thank you very much, Council. Council, give me just a second. All right, Mr. Roman, you may begin.
Let me throw out my softball real quick, just to make sure you agree. Do you agree that our review is de novo?
NCR agrees, it's de novo.
Okay, thank you.
Good morning, your honors, and may it please the court. Counsel for Raytheon has just asked you to overturn three basic aspects of Kansas black letter law. And I'd like to enumerate those. One is that when a merger happens, the survivor of the merger assumes the liabilities of the company that it merged with. In this case, Raytheon assumed the liabilities of E-Systems Inc., with which it merged. E-Systems Inc. assumed the liabilities of ECI Corporation, with which it merged. And ECI Corporation assumed the liabilities of Standard Precision Inc. It wasn't a merger. Standard Precision, Inc. dissolved in 1965. And its parent, ECI, assumed those liabilities. It's in the record. So the Standard Precision liabilities and the ECI liabilities all came to Raytheon by way of merger. There's no escaping that for Raytheon. The second aspect of Kansas black letter law that Raytheon has asked you to overturn today is the principle of transferee non-assumption of liabilities. The Comstock holding, and I would argue that it's different than what counsel said. The Comstock holding is that a transferee of corporate assets is not the assumption of liabilities, is not the assumer of the liabilities. That's the general rule of Comstock. Comstock also has some exceptions to that general rule of non-liability. Those exceptions require that the transferee assume all the assets of the transferor.
Why?
Because if you have a transferor that still exists, plaintiffs and claimants can still sue that transferor. And in this case, the transferor, ECI, is Raytheon. ECI, when it was a corporation, issued a dividend to NCR. NCR took that dividend. Dividends, like other corporate asset transfers, do not transfer liability. A shareholder in a corporation getting a check from AT&T as a dividend does not get AT&T's liabilities.
But it also doesn't get AT&T's business or going concern.
It does get assets cash. It doesn't get the going concern, right? The going concern aspect of that has never been recognized by any Kansas court as leading to a transferee liability. It's only been recognized as leading to liability in 2 cases. And in both of those cases, the transferor ceased to exist. So a transferor transfers some, but not all assets to a transferee. Okay? There's never been a Kansas case that says the transferee gets those assets, gets those liabilities. And there's only been 2 cases from no Supreme Court in any state that says the transferee gets those liabilities. And in 2 intermediate appellate courts, they said that. But in those cases, the transferor, even though they didn't transfer all the liabilities, nevertheless, all those assets, transferor, even though they didn't transfer all those assets, nevertheless went out of business. There was no transferor to go after by the claimants or the plaintiffs.
Does our analysis change at all, given the fact that new ECI, if we're going to call it that, was kind of a holding company that as assets were being transferred to different places by way of the merger?
No, because that's not factually correct. And new ECI was an ongoing business. After the dividend, new ECI was still a subsidiary of NCR. It had a business. NCR sold new ECI to E-Systems Inc. for $19 million in 1976. New ECI had assets, it had liabilities, including these liabilities, it had business. And NCR sold ECI to E-Systems Inc., which is now Raytheon. And those liabilities are now Raytheon's. The third aspect of Kansas black letter law that Raytheon asks you to overturn is that in summary judgment, you have to have a genuine dispute as to a material fact. In this case, there's nowhere in the record that says that NCR disposed of the contaminants at the site. It simply does not exist. The Kim Walsh affidavit that counsel mentioned said that NCR used these solvents in small quantities using a paintbrush type applicator. And that the workers really didn't know exactly where the waste went. They thought it went out in the trash. But there's no evidence, and Kim Walsh's affidavit says there was no dumping, there was no spilling, no pouring down the drain, either the sewer drain or the sanitary sewer or the storm sewer. There's no evidence that NCR disposed of these chemicals at the site.
Is it not enough that NCR was using the chemicals? I mean, typically causation is a fact question.
It's not enough because there's no evidence that those using those chemicals caused the contamination at the site. And here's why. Council mentioned a sump. The sump, both experts agree, NCR's expert, ECI's expert. There's a sump, basically a pit in the site that has these chemicals. That pit, the drain to that pit was sealed over in 1969 before NCR got to the site in 1972. And council mentioned, well, it was only one drain. It was the drain. Not even their expert says there was more than one access way to the sump.
Was the sump the sole source of the contamination?
It was the sole source of the VOCs. There was some radiation contamination that was not associated with the sump. But there's no evidence that NCR used any radiation. That stopped in 1968. So again, going back to the black letter law that Raytheon wants you to overturn, there's no evidence that that NCR disposed of any hazardous substance at the site. And if you want to go back to the idea of responsible person and causation, NCR cannot be a responsible person because NCR could not have caused any of the contamination at the site because they did not dispose of any hazardous materials at the site. It's not only not in the record that there was no disposal, it's impossible they caused this contamination because the sump was sealed over. And I want to add, Your Honor, that Raytheon's expert, John Connor, completely ignored the fact that the drain was sealed over. And he had to ignore it because otherwise there could be no contamination by NCR. I noticed I'm 25 seconds over time. So at this point, I invite the panel to ask me any other questions. If not, I'll go to KDHE.
I wanted to go over a couple other key facts raised by Raytheon. So they raise as key facts that should have precluded summary judgment on the direct liability issue, that there were empty drums on the site. What do we do with that?
Right. There was a guy who either owned or worked for Seco, which is the company that owned the site. NCR never owned the site. It was rented by Standard Precision. But anyway, Seco guy comes back in 1977 after NCR left the site in 1974 and says, oh, there were drums on site. There's no evidence that those drums were NCR's drums. There's no evidence of what was in them, and there's no evidence of how they were disposed of. All he says is, I'm back now in 77. NCR left in 74. There's drums on the site. That's not evidence of disposal by NCR.
They also raised the point that NCR used fluoroethylene new. Is that disputed?
It's not disputed. Fluoroethylene new is a brand name for a solvent. And Kim Walsh says that NCR used it either at the site or at a different place where NCR moved after 1974 called North Rock. It's a problem with the affidavit that the witnesses didn't know exactly where it was. But even assuming that NCR used chlorethylene new at the site, there's no evidence that it was disposed of at the site. No tanks, no pouring chemicals down the drain, no throwing it in the backyard. The best that the witnesses remembered was it was possibly thrown out in the trash, I think is the way they would put it. I would like just, in conclusion, we heard counsel use words like magic trick and absorbed, okay? The reason he uses those words is that Raytheon can't win on the law. There's no magic trick under the Kansas statutes. There's no absorbed under the Kansas statutes. Raytheon is the liable by merger to the liabilities of ECI and Standard Precision.
Thank you, counsel.
Thank you.
Right. Counsel for KDHE, come on up.
See, the clock's still running.
We'll give you, 15 extra seconds for
Appreciate
the
it.
login.
May it please the court. This court's decision must ensure consistency with the frameworks and the policy purposes applicable to the legal principles concerning the three issues presented by this case.
Counsel,
yeah.
before you jump in, what is KDHE's dog in this fight?
Well, at least for specifically the corporate successor liability issue, the application that Raytheon is proffering to this court, that a discrete business unit or any kind of business unit or any transfer of assets will transfer liability while the transferee or transferor corporation still exists, creates an exceptional issue with the agency's ability to identify responsible parties. When it comes to, in this case, not even all the SPD's assets were transferred over to NCR. There was a transfer of certain assets to the Edo Corporation prior to that. I believe those were aviation instruments that also would have potentially utilized any of the solvents that are at issue in this case. There was also some portions of it that were then given to, I believe, Scott's Electronics, which was a subsidiary to.
So I suppose I understand that KDHE has a general interest, as we all do, in making sure that we have sound law in Kansas. But I mean, you'll just apply the law that exists. And so I'm having a difficult time understanding what the standing is of KDHE to argue on the liability question.
On the corporate successor liability?
Yeah.
I mean, it's KDHE's order, and it's KDHE's duty to identify, or not duty, but responsibility to identify what responsible parties there are. And if it's inconsistent with this test, which says, hey, if a corporation transfers assets or transfers substantially all assets or even a portion, but continues to exist and that company itself is not liable, to what extent? Because in this case, all of SPD was transferred, but in other cases that might not be the factual situation. It could be a portion of it that's divided among two individuals, and then who is responsible at that point in time. The test that's being proposed by Raytheon is unwieldy and is inconsistent with just the factors set out for mere continuation or the other exception, because those tests contemplate that it is corporations or at least business entities with separate legal identities that have liability, not a division. And because of that inconsistency in this law, and because the results in subsequent cases or potential cases would make it difficult to perceive who is, the actual party here. If anything, the original concept should be, and consistent with the policy purposes of, us finding responsible parties and having them pay for resolving the contamination, is that it should really be both. It should be the liability of both parties because they both benefited from the operations of ECI, technically speaking. This wasn't briefed and we abandoned that, argument because the test says corporation. But, in light of, the policy purposes, because Kansas statutes mirror the Superfund Act, the Federal Superfund Act, which, liability for environmental contamination is joint and severable. If you're in it for a little bit, you're entirely responsible. That operationally is the purpose to ensure.
I suppose in light of that, that's why I was a little bit surprised, I suppose, when I saw that KDHE had changed its position with regard to the second issue that we were just discussing.
And that's just specific to the text of that law, that it is about a corporation. And because of how this court or how the adjudicator must identify who bears, favorable inferences from the facts. And in this case for NCR, that was NCR. But because of these issues, it is inconsistent to say a division can be separated from its corporate body. And that corporate body can continue to exist without any liability. And that goes against the policy purposes outlined in Wells Fargo. If there is no policy reason, if there is no need to ensure a remedy is available to creditors, then corporate successor liability doctrine exception should not apply. And in this case, it's very clear and very simple to say Raytheon absorbed ECI. ECI had those assets. ECI benefited from it. ECI continued to exist. Raytheon purchased ECI's stock for, I believe, $19 million. And ECI still maintained, or at least the record doesn't identify, what happened to the rest of its divisions, because SBD only amounted to about, I believe from volume 7, page 7, in terms of assets, only 8.6% of ECI. So the remainder of ECI, at least from the records, continued to exist, was still there, was still conducting operations. And specifically in the 1971 annual report of NCR, it identified that ECI was conducting different operations now that were focused on national defense, and therefore it shouldn't get away scot-free. It should still maintain.
Let me see if I can summarize what you just said. KDHE doesn't really care who the responsible party is, but you want to make sure that somebody's responsible. Is that part correct?
That is correct. And
in this case, the reason why you've kind of shifted positions from below to now is just the posture that this case has reached us.
exactly, it's just based off those principles of, where the inferences lie, how the test is set up, and how to operate and functionally conduct that test.
Now, you've heard, I'm going to go back to my standard of review question. You've heard both of these fine gentlemen say that it's a de novo review. Do you stand by your previous position, or do you recognize that our review's de novo? Because that can make a big difference in a summary judgment.
Absolutely. We still believe that the test should be an abuse of discretion and de novo, as Wells Fargo's applied that test.
What discretion can you have if summary judgment can only be granted on uncontroverted evidence?
It's just the weighing of the factors. If we can find the facts that exist that are applied to those tests, and those are legitimately identified within the record, the weight that the ALJ or KDHE applied to those factors should be within our discretion.
Isn't weight inherently an evidentiary issue?
Potentially, but at least in terms of how this test is applied, Wells Fargo expressly states not one particular factor is outweighing others, and one may not necessarily be decisive. But if we looked at the case law that came after Comstock, as NCR identified.
That might be why we have evidentiary hearings. It's for that very reason. I think
Yeah.
that's what Wells Fargo probably would have preferred.
Absolutely, but in this case, it seems that both the ALJ as well as the district court and the secretary identified there is no further evidence. And to that point, now when we're looking at NCR's direct liability, what evidence has Raytheon presented that proffers more than mere speculation? Because
Is the result different if based on our standard of review? Would it make any difference?
it should not, because under the law, Comstock says we apply the corporate successor liability sparingly. And the reason for that is only to ensure a remedy is available, and a remedy is available.
So successor liability is the exception, not the rule.
Absolutely. And that's not to say that there would be a different set of facts that would allow for instance, a division or transfer of a division to transfer liability. If that predecessor corporation ceased to exist, that could happen. In this case, if ECI continued to exist and did not merge into Raytheon, there would not be a question that ECI would be liable, because it remained a company. It still bore all of the liability from its operations when it had SPD as part of its company and not as a subsidiary, which is how NCR's relations with ECI was maintained for the entirety of that time before it was sold to E-Systems. I see my time's run out, but
Because it took you a few seconds to wander up, I would like to, for you to address the issue with regard to the remaining liability with regard to these VOCs. Is there any evidence of VOCs?
there's still evidence of VOC contamination that exceeds, I believe, the last report was conducted by EPA after their radioactive materials removal action, but there's still potentially a source here. There's investigation contamination that needs to be identified, and that should not go on necessarily the taxpayers, which would be the case if there was no responsible party here. And in this case, that responsible party is Raytheon, and it is Raytheon through the simple act of they merged with ECI.
But so you no longer take the position that NCR is independent liability for those VOCs?
Only if this court were to find that, for instance, that the inferences that need to be, gleaned from the evidence are not favorable to NCR, but based off of, qualities of summary judgment and where that was directed, NCR is the only party that is going to be targeted or bear any kind of consequence for finding of summary judgment in favor of KDHE on that point, if it was back then. But to briefly conclude on the due process issue, which I didn't really get to, when it comes to that one, there is no due process violation because that is a separate agency action that's not before this court.
Is that what the federal lawsuit was about? Or do you know, you weren't involved in it?
I wasn't involved in it, but my understanding was they said, hey, there's still an ongoing case here. It's still at, an Office of Administrative Hearings, and they have yet.
And it was, I think it was dismissed without prejudice.
Yeah.
So who knows what may happen?
Yeah, and there's still recourse for Raytheon to, be able to potentially address that.
But you're saying in this case, due process is not an issue.
Exactly. It has nothing to do, whatever that settlement agreement was with SECO, has nothing to do with any kind of finding that Raytheon is the corporate successor to ECI. It does not change that fact. But briefly to conclude, this court to render a decision to find NCR absorb liabilities, but that ECI can continue to exist, has to resolve all the contradictions, existing law, common law that designates that a division is not a separate legal identity. And to do that would create, especially with the tests as they are outlined, an inability for any lower courts or any agencies to really determine or perceive what are the extents, how do we apply this test, what assets are these assets, if they're multiply, divided, how is that operable? So the only real answer here, the easier answer, I suppose, if you didn't want to put too much work in the decision, is to find that Raytheon absorbed ECI and is liable as their successor. And in regards to the other issues, direct liability, there is no evidence beyond speculation. And if the facts were different, if NCR was the only entity that ever operate there for those operations and use solvents, it might be sufficient. But here, there is no evidence. There's still two companies that work there, did similar operations resulting in contamination. And for that reason, for these reasons, KDHE would ask that you affirm the decision below.
Thank you. Thank you, Council. Council, you have 5 minutes plus a little bit if you need to.
Thank you, Chief Judge. I'll only use a little bit if you make me, I think 5's good. No, I appreciate that. But based on what I'm hearing, I think the key thing for me to focus on is to go back to a couple of these Kansas cases, because in response to what NCR has said, I hope it's clear that we agree with the rule that a survivor, the surviving company assumes the liabilities of merger. That rule is good for us. The question is, what was still there in ECI when E-Systems bought it? And our entire point is that the liabilities of SPD had already been taken with the other SPD assets and operations.
If someone is a victim of a previous action by a corporation, that then I'm trying to think of like a member of the public who is harmed, who wants to sue the responsible party. If a division transfers liability, how does that person figure out who to sue?
I mean, that's a fair question. And that is really, the answer is in the Kansas cases. This is exactly what happens. A plaintiff sues one or two entities. One of them raises their hands and says, not it. here's why. And then the court deals with that. And so that argument will be made whether they sue who the defendant thinks is the right entity or the wrong.
So you just sue everybody.
Well, I mean, that's the smart approach, right? That's not an unusual or strange aspect of Kansas law. If you're not sure, you sue. If you don't know it's an issue, you sue someone, they raise it as a defense. Now you have the opportunity to perhaps sue the other one, or you make your decisions based on that. But the thing that NCR has said today is that, well, the transferee doesn't get liability under Comstock. We agree with that if we're talking about a Comstock style transaction. What NCR is saying, though, does not appear in Kansas law. They've said, here's the rule we glean from Kansas cases today. They said, if the transferor company still exists, we win. No Kansas cases dealt with that situation. I don't know if it's true that no Kansas cases dealt with that situation, but I agree that no Kansas case has said that's the factor we look to. The Kansas cases don't say if there's a transferor still sitting out there, that's who you sue. They look to where did the operations go? That's what happened in Ledbetter. When one company winds down, the obligations are imputed to the new entity that carries on its business. That was the holding in Avery. They said this quote unquote sale to the new company was really just a mere continuation of operations to avoid liability. And really compare that to Stratton, where the same rule was cited, but the plaintiff lost, no successor liability was found. And in that case, the defendant did not continue the transfer company's contracts, etc. Okay, there's a pretty clear distinction there. What happens to the operations? And that's a bad fact for NCR because their own battle plan says this dividend in kind is going to be not just the assets, it's also going to be the business. And there were other facts in the record that showed that they truly did continue the operations. They serviced the same customers, they honored old warranties, they held themselves out in litigation to be a successor in a different sense. They were making the same products. They took the employees. They made much of the fact that SBD was not a formal company, but it was discreet enough. It was formal enough for them to paper up the transactions that they did. They said SBD must be a thing because they said, we're going to transfer its assets. We're going to transfer its business. That wasn't a magic trick. That didn't sever the liabilities. So that's important. When we look to the argument of the KDHE, I think it's very clear that it's very important that we're here on review of a summary judgment ruling. There should not have been a weighing of the evidence. If there was any evidence and from which the non-movement could show a favorable result, summary judgment should have been denied. And here, all the inferences from the fact record should have been made in favor of the non-movement. The fact that we were tossed out on summary judgment is important. That's not just why there's de novo review, but that's why there was error. And finally, to the argument that successor liability is the exception, not the rule. It depends on the transaction. If I buy a truck from a plumbing company, I'm not going to be liable for the plumbing company's negligence in repairing somebody's home, right? That's pretty straightforward. But if I buy the operations of the plumbing company, if I buy its contracts, if I, buy its permits with the state, then I think we may have a different situation. And that's our point here. The fact record below was not one to support the summary judgment rulings we've got. And if viewed in light of even just the Kansas cases that don't explicitly speak to what about the fact that SPD was not a defined legal entity, the answer should be fairly clear.
Any other questions from the panel? Thank you very much.
Thank you, Your Honor.
Thank you to all counsel for a very well argued and well briefed case. We will take the matter under advisement and issue a written decision as soon as we're able. So thank you very much. I understand that we need to take a couple of minutes to move things around, and so we'll go on ahead and do that. And in the meantime, I will call the second case of this morning's docket. That case is from Jackson County, case number 126825, State of Kansas, I believe, versus Scott Darren Brockman, appellant. Parties, please come forward and get situated. Yes. Ms. Chalmers, you have much room.
Killed a lot of trees.
Oh. All right, would the parties please state their appearances?
Hi, good morning, Your Honors. Corinne Gang of the Appellate Defender's Office appears on behalf of Scott Brockman, and I would request 3 minutes.
3 minutes are granted.
May it please the court, the state appears by assistance of General Madeline Chalmers.
Thank you very much. And Ms. Gunning, you may begin. With the caveat, if you could give a minute or two
Yes.
and also give me a minute or two to figure out this, that would be great.
Don't tell our chief judge, but I don't use that.
I'm trying to jump into the 90s. So
I still use a paper possession arrow when I work the stores table at basketball games too.
So
So
I think we were talking a little bit before the arguments about like, depending on the panel, that appears or it doesn't appear.
right, right. We're just,
some are more tech savvy than that.
right. I don't know if this counts as being tech savvy, right? But go on ahead and
Okay, although we have far fewer attorneys than the previous case, I would say that this case is just as important, obviously, and but it is a little bit more straightforward. In this case, Scott Brockman went to his aunt's house to get his belongings from his shed he was storing there, and tried to tell her ahead of time he was coming. Showed up, knocked on her door, she didn't answer, so he just went to the shed. And she, not being aware that he was there or that it was him in her shed, called the police. After the police came and talked with Barbara and Scott, they ultimately determined that he had permission to be there and wrapped up their investigation of the disturbance. But one officer did notice there was some gravel disturbed by Barbara's car, which is right near her front door, where Scott had been standing during the interaction. A review of the dash camera footage at that time showed Scott standing by the car and at one point kicking the gravel in that area. When they noticed the gravel disturbed, they saw a small baggie with methamphetamine in it and ultimately charged Scott with possession of that methamphetamine as well as the baggie holding the methamphetamine. In this appeal from the jury trial determination that he was guilty of those 2 offenses, Scott argues that the state failed to prove that he possessed the baggie and the contents within based on constructive possession. So he requests that this court vacates his convictions. So particularly, we're talking about joint or exclusive control of the baggie, the element of possession in this case. And because we were challenging it based on the sufficiency of the evidence, this court determines whether it is convinced a rational fact finder could have found the person guilty beyond a reasonable doubt based on a review of the evidence of light most favorable to the state. Again, we're focusing on the single element of possession, and the state must prove that Scott both knew of the contraband and had some intent or right of control over it. And they did not prove exclusive control. It was not found on Scott's person, so they had to prove joint control of it. And there are several factors considered. Those factors from case law are his past use or sale of drugs, which was not present in this case, his proximity to the contraband in this case, the location of the contraband, and then any incriminating statements or suspicious. And Scott maintains that based on what the state focused on in this case, they did not prove that he possessed this bag jointly and exclusively. He was standing near where the bag was found. And the state points to the fact that his behavior was odd or suspicious. He was, I mean, I know this is a fact question for the jury, but I don't think that his standing there and sort of shuffling around is odd or suspicious behavior, particularly given the presence of police.
But I mean, it strikes me that at least the argument was that this baggie was found and it had some gravel over it, and so it looked like maybe he was kicking the gravel around. I mean, is that circumstantial evidence from which the jury could conclude that that it belonged to him?
I guess my read of, I mean, it would be, I suppose, I saw Scott kick the ground in the video a single time. Moving around on the ground, you're just walking on a gravel road. Driveway. I don't know that that's evidence that he was, repeatedly kicking over the dirt. I saw him kick one single time, which is also consistent with the idea that he looks down, he sees something and he's like, oh, well, I don't want to be associated with that. So he kicks it away. So he was also all over the property. He did stand in that spot by the car for a short period of time. But he was all over the property. Lots of other people were all over the property. And just mere proximity, his proximity at one point in time, many people who were there could also be considered in proximity to.
But where he was found, it was where he was detained. He was detained next to a car. Is that right?
I mean, I suppose I'll take issue with saying that he was detained. He was asked to stand still.
And put
Because
his
there was
hand-
one officer.
It was where he
Trying-
was standing anyway.
Yeah,
Right.
there was one officer trying to control a situation with two people until the second officer arrived. And so because he was trying to talk with one person, he asked Scott to try and stay in place. Scott seemed to have some problems with that. And so he said, stay right there, put your hands on the car. You stay there while I'm talking to her. And then the evidence that Scott put on demonstrating that he couldn't actually put his hands in his pocket. I didn't see, obviously you all have the video, the state's argument was that he reached in his pocket and you could see him throw something on the ground and then kick it immediate laughter. I watched the video more times than I, probably should have. But a lot of times I never saw anything actually leave Scott's pocket, leave his hand. And so I don't think in this case, if we're relying just on his mere proximity, which a lot of other people have mere proximity to the car, and then his movement during the time that the first officer was there, I don't believe that shows that his movements were odd or suspicious behavior related to that baggie, or that his mere proximity is enough.
Keeping with the prior arguments that you got to sit through, I'm going to ask you a standard review question.
Yes.
And I think you've already said this, but I just want to make sure. We do have to view this in the light most favorable to the state.
Correct.
Okay. The jury got to see this video, didn't
I presume they watched it, yes.
Right. So you and I may watch it and see something a little different, but that's not our role, is to weigh the evidence. Ours is to say, based on light most favorable to the state, reasonable inferences to the state, could a rational jury have concluded he was guilty beyond a reasonable doubt? Isn't that really the only issue in front of us? Not.
Yes.
Yeah. Okay.
Yes, and I be honest, I understand the difficulties with this case.
Right, and that's why I don't want to jump on your head.
Yes, and so, that's why I tried to, couch my argument in.
A nice instructional error would have helped you a lot.
But whatever, the court did everything great, in this case, instructed as everybody requested. And so in this case, I couch this argument in terms of how the state argued what the evidence showed. Obviously I did not raise prosecutorial error based on that argument. It's just by them saying he dropped it. You can see him throw something on the ground. My viewing of the video is not that. Again, as you have said, Judge Barnes, the jury might have seen it differently. So it seems the state focused on these two factors for joint or exclusive possession. And Scott maintains that there's not sufficient evidence to support those factors to show that he was in joint or exclusive possession of that bag.
Are there other questions from the panel?
No.
All right, thank you very much.
Thank you.
Do you agree with standard? No, I'm teasing. I just wanted to ask everybody.
Everyone should get a standard.
I do in fact agree with standard review, and applying that standard review, the state wins. In this particular case, the defendant was on his mother's property. The officer walked up to the front door with the mother, the defendant kind of disappeared. He goes actually around the car, so the officer can't see what he's doing at the time. And the dash camera catches what he's doing. He does put his hands in his pocket. He fidgets as he does that. I thought I saw something drop, but it's dark in the video. You can't clearly see one way or the other. And then he does some scuffling, and lo and behold, that is precisely where the drugs are found. Viewed in the light most favorable to the state, the defendant's conviction needs to be upheld. There are no further questions?
Other questions?
Thank you, Your Honor.
Thank you.
Thank you all.
Counsel, it's gonna take me just a minute here.
Where you are, 14 minutes.
I will say, unless there are any other questions from the bench, I was just here. So I would waive my rebuttal. Unless there are
Any
any
other questions?
No, haven't.
No.
Thank you.
No, but I did, let's just, for the record. Like, I got it right. Yeah.
She could have done it.
Sorry.
Thank you both.
Thank you very much. Counsel, thank you for your arguments in this case. Thank you for your fine briefing, and we'll take the matter under advisement, and we'll issue a written decision as soon as we're able. So thank you very much. With that, we will call the final case on this morning's docket. This is also from Jackson County, case number 127362, State of Kansas Appellee versus Timothy Washington Jr. Appellant. Would the parties please state their appearances?
Dylan Pryor, Assistant Appellate Defender, here on behalf of Timothy Washington Jr. And if I may request 3 minutes for rebuttal.
You may, and I'll figure out a way to stop this in just a second.
Please record the state principal assistant solicitor general.
Thank you very much. Mr. Pryor, give me just a sec. All right. If you would just take a minute or two to summarize the case, and then I'll go ahead and swear the time.
Certainly. May it please the court. Kansas Highway Patrol Trooper Alexander Morris was sitting along US 75 just north of Topeka when a man, Hudson Rolls, approached her and told her that a black man in a Chevy truck had just pointed a gun at him. Soon after, Trooper Morris saw a black man in a Chevy truck drive by, so she began to follow it. The man in the truck appeared to be upset that he was being followed, and he eventually hit his brakes, causing Trooper Morris to believe that a traffic infraction had occurred and to conduct a traffic stop. Trooper Morris approached the vehicle at the driver's side, looked inside, saw there was a gun on the center console. She asked the driver, who was later identified as Timothy Washington Jr., to put his hands on the wheel 3 times, and she asked him to turn over his driver's license. Mr. Washington never turned his driver's license over to Trooper Morris, but he eventually did turn it over to the second deputy that arrived on the scene. Based on these facts, the state charged Mr. Washington with aggravated assault and felony interference with law enforcement. Mr. Washington went to trial. The jury found him not guilty of aggravated assault, but guilty of interference with law enforcement. And here's where my argument starts. The jury found Mr. Washington guilty of interfering with a traffic stop, nothing more. Mr. Washington realized that the jury's verdict could not support a conviction for felony interference with law enforcement. So he filed a motion notifying the district court that it had to sentence him to a misdemeanor conviction. The district court, however, instead of recognizing that its power to punish Mr. Washington was controlled by the jury's verdict, went beyond the verdict, delving into its own recollection of the evidence to find the fact necessary to increase Mr. Washington's penalty to a felony. This was judicial fact finding.
So he could have done that if it went to a jury, right? The judge could have done that, but your argument is it should have went to, that issue should have went to a jury.
Exactly. When we're talking with interference with the law enforcement, the severity levels depend on what sort of case or rather crime that the interference occurs in. For it to be felony interference with law enforcement, the interference has to occur in the case of a felony. Here, and so although it's not part of the substantive body A3, it's in severity levels B5, because that's a sentencing factor, we treat those as essentially elements. The jury has to find that to increase it from a misdemeanor to a felony. And based on the jury's verdict, there's no way to tell that the jury ever found that. So when Mr. Washington said, based on this verdict, it's essentially a verdict for a lesser included for misdemeanor interference. He told the district court, I'd like to be sentenced to what I was found guilty of, misdemeanor interference.
Let's say we agree with you, assume that. And what's the remedy here? He was put on probation. He's done with it. If we send it back for resentencing, he could potentially go to jail.
I would actually say that if the state tried to put imprison him in county jail for this, that would be a vindictive prosecution.
Well, it could be, but then we'll be back again over whether it's vindictive. I mean, as a practical matter, do you just want us to rule as a matter of law that this is a misdemeanor?
Essentially, yes, because Mr. Washington is still suffering consequences from this erroneous sentence. He's still.
Which is why it's probably not moot. And I think the state even agreed with that.
Exactly, even in light of like.
But what I'm just thinking of practicalities here is, sometimes what we argue in appellate courts is not in the best interest of the life of someone. If we vacate this and send it back for resentencing, and yeah, sure, you could argue vindictive, but when you vacate a sentence, it opens it up to whatever the full realm of possible sentences would be.
I understand that, and I think.
You talk to your client about that?
I believe that'd be confidential, and so I don't want to.
Well, have you talked to your client?
Oh,
at all?
Yeah.
Okay. I want to make sure you did, because I don't want to set somebody up. And this isn't the first case that this type of thing comes up. I just want to make sure we're not setting your client up for something worse than, that's why I'd like to know what you really want us to do.
I understand that. And Mr. Washington raised this because, as he said, the jury never found me guilty of a felony. He didn't think that not turning over his driver's license when the trooper was conducting a traffic stop regarding a traffic infraction.
Could we just find as a matter of law this was a misdemeanor based on the jury's verdict and be done? And the state can think about that too. I think Judge Malone has done that in a couple of cases.
I do believe.
Not sure if it's right or not, but whatever Judge Malone does usually is pretty solid.
I do believe you could, and one of the reasons I didn't raise sufficiency is because Trooper Morris did have two bases for conducting the traffic stop, and so that's why I felt if I raised that it's insufficient to support felony conviction, then in the light most favorable to the state, a traffic stop could include the felony, and so but that's why I felt that it was most proper to say. No, in this case, the district court went beyond its power because it couldn't just look at the verdict and say, I think one of the problems is the district court judge that sentenced Mr. Washington also presided over his trial. The separate district court judge had gotten this jury's verdict, but had not presided over the trial and had just presided over sentencing. Mr. Washington said, they never found that I committed interference in the case of a felony, and therefore I should be sentenced to a misdemeanor. The district court judge who had not presided over the trial could not look at the jury's verdict and say, well, no, traffic stop means felony. You can only do that when you go beyond the verdict and go and find those facts.
Would it matter if the district, in that case, would it matter if the district court judge would have presided over the trial or not? I mean, the verdict speaks for itself.
Well, exactly. The verdict speaks for itself, and there's just nothing in there. The only way that you can get to the term traffic stop, meaning an investigation into a felony, is by looking beyond the jury's verdict to look at the facts. And Trooper Morris said the traffic stop was for a traffic infraction as well as to investigate Rolls allegations. The state in its brief concedes that term traffic stop means both reasons. And so because there's not that additional fact that it was specifically for Trooper Morris investigation into Rolls allegation, then instead there's a perfectly valid conviction for the misdemeanor.
I'm going to switch gears on you. So the state cages this more as an instructional error, and you've got this as an Apprendi error.
Correct.
So tell me why this isn't an instructional error, because you can see that in the charging document, it's clearly charged as a felony. Somehow, for reasons unknown, it ends up in instruction number 8 as a traffic stop being the basis for the interference. And I went back and looked at the record. There's no conversation about it during the instructions conference. And this happens sometimes, but why is this not an instructional error?
I'd say it's specifically because of the district court's action in this case, finding the fact, but also that's not the issue that Mr. Washington raised, because from the state's perspective, there probably is a mistake with instructions. But from Mr. Washington's perspective, this is a perfectly fine lesser included instruction. There's a valid conviction. He definitely interfered with Trooper Morris conducting the traffic stop to address the traffic violation. So it's essentially as if he got The jury was instructed on the lesser included, and they found him guilty on the lesser included. And so what he takes issue with is the district court saying, well, the way I remember it at sentencing, when he says they didn't find the fact necessary to increase this to a felony, the district court saying, well, the way I remember it was there was two reasons. She was following because she was investigating the felony, but then he commits the traffic infraction. And so I just don't know. I'm going to find traffic stop to include that. So this, but even when we do have these omitted elements, say like in a Jessica's Law case, when there's say the jury didn't find that a defendant's over 18 years old, that's still looked at as an apprendi error. If the judge says, well, they look at the evidence, they find, well, there's evidence that the defendant testified, I was 37 years old. I'm going to find that if the jury was properly instructed, then they would have found that. They would have found that fact. So I'm going to sentence them to an off-grid instead of an on-grid. And so this court treats those like apprendi errors rather than merely instructional errors, or at least when the appellant raises it that way. And so because this is an apprendi error, that's the way Mr. Washington raises it, and the state cannot replace his argument with one that suits it better. And if I may, Judge Bruns, talk about the standard of review, because this is an apprendi error. I want to hear it. The standard of review should be constitutional harmless error. I think another reason why the state might view it as instructional error is because that places it in clear error standard of review. But what we have here is a constitutional error. The jury found the fact necessary to increase Mr. Washington's penalty that a jury did not find. When we have these constitutional errors, the burden is on the beneficiary of the error to prove beyond a reasonable doubt to this court that the outcome would have been the same.
So technically, we have two errors, potentially. We potentially have an instructional error that you didn't raise, which I can't blame you strategically. That was a good move. And then you have what I guess we'd call an apprendi error.
Exactly, just judicial fact finding. That's what we had here. And that's what Mr. Washington takes problem with, is that the judge found a fact that the jury did not find to increase his penalty. And so this court reviews apprendi errors for the constitutional harmless error. The beneficiary of the burden, or the beneficiary of the error, in this case the state, has to prove to this court beyond a reasonable doubt that the outcome would have been the same.
Why wasn't it harmless? Because he got probation.
Well, it's not harmless because, well, first, it's not harmless because the state's abandoned any argument that it is harmless. It's the state's burden to show this court beyond a reasonable doubt that the outcome would have been the same. The state did not brief it. They raised this as instructional error in their reply brief. In their supplemental brief, they reiterated that they viewed this more as an instructional error. So the state has never even argued in the alternative that this was harmless.
So they waived that argument.
I would agree. And so this court should not even engage with it. But even if this court wants to discuss harmlessness, the state cannot meet that high burden to show that if the jury had been instructed differently, that the outcome would have been the same. There's no way to say that if the jury actually had, say, the instruction for the greater, for the felony interference, for interfering with the investigation into Roll's allegation, as well as the lesser, the investigation basically into the traffic infraction, that the outcome would have been the jury finding that Mr. Washington interfered with the felony investigation. I mean, an officer asking for a driver's license is part and parcel of any traffic stop for a traffic infraction. If you ask 12 people, is not handing over your driver's license during the traffic stop a crime? I think they're going to say yes. You ask those same 12 people, is not handing over your driver's license quick enough to an officer, does that substantially hinder or burden an investigation into felony? I don't think you're going to have the answer. The state has not proved that, and that's what they were required to do. And because the district court erred when it found the fact necessary to increase Mr. Washington's penalty beyond this prescribed statutory maximum, and because the state has abandoned any argument that the district court's error was harmless, this court should probably find that it's just vacate and find that he should have been sentenced on a misdemeanor, or alternatively,
If we can do that.
if you can. If not, I trust in Mr. Washington's constitutional rights that the state will respect those and not try to imprison him just because he succeeds on appeal. So unless the court has any further questions, I'll be back up on rebuttal.
And that, I guess when you come back on a rebuttal, I would just like you to think through the remedy on this a little bit and make sure, you know, you're asking what you believe your client would want, because I do think that is a potential risk. We say that all the time in district court, be careful what you wish for. If this comes back, we're starting from scratch and on the sentencing in this case. So that I just would like to hear a little bit more about your proposed remedy.
It's one thing for us to vacate when, you know, let's say it's, you know, it'll lower the criminal history score and it'll now become presumptive probation versus but this case, theoretically, he could face a more harsh penalty than what he had before.
Certainly. I'll think on that and I'll be back up soon. Thank you.
And I know practicalities are not always considered in the law, but sometimes they should be.
An Apprendi issue is an instructional issue. What happens with Apprendi is that the jury did not make a factual finding. The only way juries make factual findings is through instructions. Here, the state charged felony interference. We don't know why it was instructed the way it was instructed. This court nor the defendant gets to control the state's charge. The state wants felony interference. In an act of strangeness to me, I contacted the county attorney and said, would you rather take the misdemeanor or redo your felony prosecution? She wants to redo the felony prosecution. So if this court is intent to reverse here, what would happen is we should go back and have the trial that has the jury instructional error. And I cited in my.
We already have jeopardy attached by way of the trial, and the issue that's been raised is a sentencing issue, not an instructional issue. And so where does this ever get to a new trial?
Well, this gets to a new trial because, again, he can't tell us what to charge. It's not.
Had the opportunity to request that instruction. And it's not Mr. Washington's fault that the state didn't request that instruction.
And then
that benefit goes to Mr. Washington. The state's error potentially in not asking for an instruction on felony interference is on the state.
we did ask for instruction on felony interference. It was instructed on felony interference. There is a particular element that is supposedly missing. But more importantly, you're bound by Kansas Supreme Court case law. In Kansas Supreme Court case law, if there's a failure to include an essential element, you would get a retrial.
But let me stop you.
Because-
The case you cited, there was ample evidence in the record of the missing element. Okay.
Yes.
So here, the jury specifically rejected your felony underlying charge of aggravated assault. They considered it and found him not guilty. So it's kind of apples and oranges. I mean, there's no evidence in the record. The jury rejected the evidence of the underlying felony. So what evidence is left that would even support a conviction?
We don't have to prove that there was actually a felony in order to get felony law enforcement. We have to prove that the law enforcement officer was investigating a felony. And here the undisputed evidence is, and there's nothing to contradict it, that that officer was investigating that aggravated assault and the traffic stop. So she had a dual purpose, like many officers often do. And we went after the investigation of the aggravated assault. So it is exactly like that case. It's entirely uncontested on the element. And for that reason also, if you're going to go in the Apprendi is somehow not an instructional error in this case, it is harmless under whatever standard you choose to use. And the state did argue, even if the error could be found, reversal is not required. I explained why. It was overwhelming and uncontroverted. That is the standard by United States in the Nieder court standard. So that is whether or not. I also said he can't meet his burden of establishing clear error, but I have also proven that yes, the error would be harmless.
So in light of the Nunez decision, I mean, is that the standard that we apply in constitutional harmless error?
Nieder?
For an Apprendi error?
Well, typically the Kansas Supreme Court in an Apprendi error has said the clear error rule actually applies. They look at it as an instructional error. They've applied the clear error rule. And so again, I cited the Kansas Supreme Court case law. I realize that the defendant doesn't apparently want to work within the Kansas Supreme Court case law and wants to attempt to. You're right. And wants to try and come up with creative and novel theories. But that's, again, typically prior to Friday and Gleason, the Kansas Supreme Court has applied the clear error standard. Council has not briefed a Section 5 separation standard, and that Gleason does throw that into a bit of a mix. So waived as far as the state's concerned. There is no freestanding Section 5 claim here, but typically if it should have been an instructional error and the state didn't present the instruction, what the Kansas Supreme Court said in Jones was one, they got to redo the trial, which is what the state wants to do if you don't find the error is harmless. And two, it is reviewed for clear error. Constitutional errors, even in jury instructions, including Apprendi, which is a constitutional jury instruction error, are reviewed for clear error. And then to the remedy in this case, I'm actually still confused on what the defendant wants, but here he was as a felony presumptive probation. He got his probation. If he goes back on a misdemeanor, and I'm not sure if he wants his conviction changed to a misdemeanor or just the sentence, but if he goes back on a misdemeanor, the court gets to resentence. There's no vindictive sentencing.
There are myriad consequences to having a felony conviction versus a misdemeanor.
Yes, I'm not arguing it's moot. I'm just saying that I don't understand the remedy that he wants, because he will risk potentially having jail time, potentially having a fine, whatever the misdemeanor sentence is. When you vacate a sentence, you get to sentence anew. So the district court will get to sentence on a misdemeanor. And the fact that the felony level was presumptive probation doesn't mean that the misdemeanor is required to have probation. And at least they're going to have a probation sentence. No, Your Honor, I am absolutely not conceding there is an error.
What about the idea that Judge Bruns raises that there are dual errors? So the first thing that happens is, for whatever reason, these instructions are based on a traffic stop in instruction 8 rather than the felony investigation. Then the second thing that happens is that despite that, the district court judge who does the sentencing chooses to make his own factual determination and commits an Apprendi violation. Is it possible we have two different violations? And if so, how do we weigh those against each other? Would an Apprendi violation take precedence because it's a constitutional violation of his rights?
I think these are all flip sides of the same coin. The problem here is that the jury did not find a fact. And the way you do that, jury finds facts as instructions. And so here, the argument anyway is that when the standard said official duty, namely conducting a traffic stop, that somehow was limited only to him stopping in the middle of the highway. What the trooper testified to, and this goes to the no error argument, what the trooper testified to was that she stopped him based on the ag assault, that it was a traffic stop for the purpose of both the ag assault and the reckless. So she used the word traffic stop to encompass both. So under that, if we're going to take literally what the evidence was, there was no error because the jury instruction matched what she actually testified to.
Counselor, in light of the fact that the jury acquitted on the ag assault charge, does that change our constitutional harmless error analysis?
No, because again, they don't have to convict of the ag assault. It's whether there was an investigation into that. That's the element. It's what is the officer actually investigating. The officer here was investigating ag assault. And then he happened to stop in the middle of the highway, so it became a traffic stop too.
That's a little different than the facts I reviewed. So the timeline of the facts that I reviewed, and I wrote this down, that she spots a truck matching the victim's or the defendant's description, driven by Washington, or the victim's description, driven by Washington. And the driver appears agitated, stops abruptly in traffic, nearly causes an accident. She initiates a traffic stop for those reasons and also to investigate the possible aggravated assault. So why can't a jury consider that testimony and agree with the instruction that her primary purpose, was the traffic stop?
Because there is no primary purpose test in obstruction. Typically, what should have happened here is probably all the traffic stop stuff should have dropped out of the instruction. In an ideal world, we would have said, namely investigating the ag assault.
What did the state request in its instructions? I mean, what did it say did they submit instructions to the court?
I don't remember seeing either side's instructions. And I did look because I was trying to figure out where this language came from.
A felony instruction. Maybe I misunderstood.
Well, and maybe I misstated accidentally something, but I meant that the instruction itself, I think, was presumed to be the felony charge. But I don't think, that language was not, I can't remember Thursday's instructions off the top of my head right now.
And the reason I'm asking is, it's been my experience that sometimes in a trial, you'll start with the crimes as charged, but as the evidence plays out, the state elects to do something smaller, and we just don't know what happened because there's no discussion, in the record at all as to how this ended up. So as our chief pointed out, why does Washington suffer from the state's mistake in doing this?
Well, Washington's remedy, assuming that there is some kind of error, would either be if he has an instructional error and I don't prove that it's harmless under any standard that may be thrown at me, which I think it is, then the remedy would then be he gets a trial with the correct instructions. It's not he gets to walk and suddenly change the state's charge. If the state intentionally said, we now want to go, and you'll see that, they'll drop charges all the time. They'll say, we want to modify the charge, we want to amend the charge. There was no amendment of the complaint here to turn it down to the misdemeanor version. So what we have here is essentially an instructional error. Again, if there was an error, I'm trying to say that there was no error by the fact that
You haven't conceded that, but we are looking at a remedy here. So here's another potential remedy. I've been sitting here pondering. Is just, even if we treat it as an Apprendi instructional error, we vacate, and instead of a new trial, you're back to sentencing, and the state could request a jury to try to prove that it's a felony.
well, other than I don't think the Kansas Supreme Court likes us to have special questions, so I don't know that we could actually.
No, but how does Apprendi work in this situation without that?
Well, that's why I don't think that this court can get to what you've just said, because if there's an instructional issue, the issue is a retrial with correct instructions. That's always the remedy.
But I'm viewing it as an instructional issue after the verdict is in. It's now an Apprendi. You are viewing both as instructional issues, I thought you said.
Right.
So if we view it as an Apprendi instructional issues, you just go back and Judge Merrick can convene a jury, and I don't think he would do that. And state could try to prove it. Which I know they don't like. As a district court judge, I certainly didn't like that type of thing.
This attorney is willing to retry the entire case. So to the extent that this court thinks that I don't believe that the Kansas Supreme Court agrees that we can bifurcate our trials like that. There's not an upward departure. We don't have a sentencing statute. No, because we don't have a sentencing statute that allows for this, is what I believe Gould was the case for the Kansas Supreme Court. This district court judge saw Apprendi coming on upward departures and did an upward departure with the jury trial. And the Kansas Supreme Court still said, you can't do that. That's not good enough because there's no statute that allows it. So I'm not
No, the Constitution
sure.
allows, but that's a different issue.
The Constitution would allow it, correct. That is a fight for a different court.
Right.
If we find that the harmless error analysis applies, how is this harmless error?
It's harmless because it's uncontroverted that the officer that we charged the felony for aggravated assault, it is uncontroverted that that officer, whether or not the ag assault actually happened, believes she was investigating an aggravated assault. There is no dispute for that. There is no questioning on that. And when you have uncontested evidence like the defendant's age over 18, and it's uncontroverted, you meet the constitutional harmless error standard. And so that regardless of whether this is harmless error, clear error, or anything else, the state can meet its burden of proof because the only evidence in this case was ag assault. In fact, he was arrested for ag assault. So we know she was in fact investigating that ag assault. If there are no further questions, the state would ask you either affirm or remand for a new trial.
Or whatever.
That's what the state wants.
Thank you.
Thank you very much. Counselor, give me just a second.
Certainly.
Who would have thought this case was going to turn out more complex than the first?
Never a dull moment in the Kansas Court of Appeals. Counselor, you may begin.
May it please the court, I've been doing some of my own pondering and I believe that this court can remand to the district court with instructions to reclassify Mr. Washington's sentence to misdemeanor or perhaps an amended journal entry of judgment. I'm happy to fall on my sword. This was my first brief and I don't want a mistake by me to negatively impact Mr. Washington. So I believe that the court can do that without imperiling his rights. And again, I trust the state not to vindictively prosecute Mr. Washington and seek imprisonment after he's already successfully completed probation just because he was successful on appeal. I think really 2 points I want to touch on rebuttal unless the court has any further questions. Ms. Chalmers said that she said that she did do the harmless error analysis. She invoked the words overwhelming and uncontroverted. I believe this was immediately after she said that this was instructional error and that it required the clear air standard of review. I do not believe like such a passing reference can be deemed adequate briefing. I don't think you can have your 10 fingers and 10 pies to make all the different evidence and say, or all arguments to say I've covered everything. She had also said that Apprendi's instructional error and it requires clear air. Chief Judge Warner, you brought up Nunez. That's not the standard for Apprendi issues. It is the constitutional harmless air standard. It is that the beneficiary of the air has to prove to this court beyond a reasonable doubt that the outcome would have been the same and that the evidence was overwhelming and uncontroverted. And I do take issue with Ms. Chalmers arguing that this was uncontroverted. There were two bases for this stop. There was the traffic infraction and there was an investigation. Mr. Washington's interference was not handing over his driver's license. I do believe it was controverted whether Mr. Washington not handing over his driver's license substantially hindered or burdened Trooper Morris's investigation into the felony. I'd say it's probably overwhelming and uncontroverted that it substantially hindered or burdened Trooper Morris's investigation into the traffic infraction. But to say that that single, just look at page 113 of volume 6, when the state asked, why did you stop Mr. Washington? Because he committed the traffic infraction. The prosecutor has to lead Trooper Morris. You also stopped him because you were following up on the investigation into Rolls allegations. Trooper Morris says yes. That is the only evidence that the state can point to say that there was an investigation into the felony. And so unless the court has any further questions, I ask this court to give Mr. Washington the sentence that the jury found him guilty of misdemeanor interference. Thank you.
Thank you.
Thank you. Thank you both.
Thank you for a very interesting answer. For briefing and time and this. Personally take the matter under advisement. We'll issue a written decision as soon as we're able. That concludes this morning's docket. This court now stands in recess until 1:30 this afternoon. Thank you.
Thank you.
All rise.
We doing your vindictive sentencing argument, right?
But
When if they get prison time, you'll lose.
Thank you.
All right.
You are not.